Next up is Perch request for a letter from council allowing beer and wine license within 300 feet of a school or church per Idaho code. And Rod Hall is presenting.
Thank you. Good afternoon. A couple of admin committee meetings ago, had a question that was directed to me to do a little research concerning the issue of granting the waiver to the Perch. The issue was whether the city could set conditions for the granting of the waiver to the applicant for being within 300 feet of the church, as Idaho code grants that discretion to the city on the issue of allowing the selling of alcohol within that 300 feet of the school or the church. Then can the city put conditions on the granting of the waiver is the issue. And then I think there was also a question of whether the city could put a sunset clause on the waiver. That would be a condition saying that this waiver would expire at a certain time. And specifically, I think there was also a question, could the city enter into a agreement with the applicant and require the applicant to do or not do something, such as discontinue the packaged beer sales, beer and wine sales, which led to the question, if we were allowed to do that, if the applicant breached that agreement, could the city revoke the permit? So on that issue, I will get to that in just one second. Then there was another question that was brought up that says, does the applicant have a duty to make sure that they are adhering to the law in their application? Looking at trying to set a condition on the applicant, there was a case out of 1951, Nampa Lodge versus Smiley, who was the governor at the time. It states on the rights of a licensee, it says, one who procures a state, county, and city alcohol license takes it subject to the provisions of the statute under which the license is granted. So basically, you have to look at the statute to see what you can actually do. There was a 1980 case dealing with a beer license application for on-site consumption. That was Mickelson versus the city of Rexburg. There was a 1968 ordinance that impliedly repealed a prior 1940 ordinance that dealt with licensing taverns within the city, basically saying that taverns shouldn't be within someplace near residential areas. And that case dealt with a technical issue concerning a savings clause in the newer ordinance. Basically, the older language, the older ordinance was vague and imprecise, and the court found that the newer ordinance was more specific and impliedly repealed that older ordinance. But the facts of that case was that the plaintiff's property was zoned commercial, and in the 1968 ordinance, they changed the ordinance within their community, and so that property fell within the commercial zone. And taverns under the city's ordinance at that time were permitted in that area. The court found that concerning the city's discretion, the plaintiff had all the qualifications to have a beer license and none of the disqualifications. It said that the city did not have discretion to deny the license, that the city's duty to issue the license was merely ministerial. So it comes to the question, if the city were to put conditions on the granting of the waiver, could the city revoke the permit if a violation of the conditions occurred? And under Idaho Code 23-1042 talks about for a procedure for other licensing authorities, it clearly states that the city can revoke an alcohol license on the same grounds as the director of the Idaho State Police. Those grounds are listed in the statute, and they are usually dealing with a list of violations, of any violations of that chapter. And basically, if you commit a certain crimes, if you're underage, selling to underage people, or you commit a felony. So the answer to the first one is that the city would not be able to enforce any conditions that the city put on a license other than those what the director of the Idaho State Police could revoke the license for. Basically, once you grant the waiver, saying the applicant now meets all of the qualifications and the city removed the disqualifications and waived the requirement or waived that being within 300 feet, the applicant's license could only be revoked on the same conditions as the director of Idaho State Police. And so if the city and the applicant entered into an agreement, say no packaged beer sales, and then the applicant went back on that agreement, the city would not be able to enforce that agreement. Then there was another issue about the duty of the applicant. Under Title 23, Chapter 10, there's a couple sections that deal with it. It says no retailer shall sell alcohol within the state until they're licensed by the city. And the applications for license shall be made under oath to the director of the Idaho State Police, then to the county, then to the city, and state that the applicant possesses all the qualifications and none of the disqualifications. So if the applicant meets all of the conditions set in state law, the city has to issue the retailer license subject to the restrictions and upon conditions in this act specified. So the applicant has a duty, and even states under oath that he is conforming to the law. So I'd say that he has an affirmative duty to research the law, because it's not an excuse under the law to say, I didn't know, I wasn't being truthful on my sworn application. It may protect him from getting into trouble criminally for that, but I think they have a duty to look into the law. I hope that answers your questions.
I've got a question or two. At this point, we're talking about the LDS Church, which is within the 300-foot limit. How about the other Campus Christian Center? That's well within.
Yes.
And so if we were to give the LDS, say that since that's, if I remember, that's 292 and a half feet, and so we're going to say that that's okay, does that mean we are automatically saying that the Campus Christian Center is okay?
I believe once you grant the waiver, you're granting and saying that it's okay, no matter how far away they are, how close they are within that 300 feet.
Okay, and since we have not heard anything from the Campus Christian Center, they apparently are not too concerned about this.
I don't believe you've heard from them.
And another question, if I might.
Go ahead.
How long did this come up with a change in ownership, or why did this thing all of a sudden come up?
I think they realized they were trying to operate as a bar and found out that it couldn't operate within our zone in the neighborhood business. You couldn't operate as a bar. Changing owners, the prior owners, I understood it, was trying to establish a restaurant and came in and did for building permit for a remodel in there to operate as a restaurant, what they still can operate as. And then in the process, has found out that they had to get a waiver from the city council to operate or sell alcohol for on-site consumption if they're within 300 feet of a church or a school.
Remember, the precursor to authorization to be able to sell alcohol in any form is regulated by the state, and the county and the city both have subsequent licenses that need it, and you have to have all three. So the state, in reviewing it for the restaurant or whatever the purpose was, noted that was not within, the city had not issued a 300-foot waiver letter. So, and it is a prohibition. The statute says that if it's located within 300 feet, that you shall not be able to sell liquor or alcohol by the drink unless the city in its discretion issues that waiver.
Has that waiver ever been given?
Yes. It's been given in a few places that have been well established in the past, typically down, if you remember the old where Peony Athletic was at 3rd and Jackson in that area, there was a church right next within 300 feet of a bar that was there, or a restaurant that was serving alcohol. And it was one of those things that it's a recognition of small towns, if you will, where you might have a main street that isn't very long, and there may be a house of worship or a school within a certain amount of feet. Strip malls, you'll see, oftentimes in bigger cities, you'll see a restaurant that serves alcohol, and there may be a church next to it, or a school or day school or something like that.
Has that one ever been given to the Perch?
Not to my knowledge.
I didn't see that when I did my research.
Okay, so there's no, then when they were doing it, when they were selling beer by the glass, they were out of compliance.
If they were in violation of the law.
Now, how that occurred Whether the state didn't pick it up, the city didn't pick it up, however it happened, it doesn't change the fact that the law is still the law, and even though they were allowed to do it, they were doing so in violation of the statute, which is one of the reasons that the state's saying, okay, if you want to do it, if you want to continue that, then you need to get your waiver at this point.
Okay.
And until that waiver comes through, it's my understanding the state will not issue the license for,
On-premise license.
yes,
Right.
consumption on premises, exactly. Packaged beer and wine sales would still be allowed in that zone and under state regulations.
Okay.
Correct, Rod?
Correct.
To clarify this, you still cannot have a bar in that zone, correct?
Correct.
Regardless of whether we give a waiver or not. You can't have a waiver for a bar. It would only be for a restaurant that would sell alcohol as an amenity to go along with the restaurant. And you could not have a bar. Is that correct?
Correct. Under Moscow City Code in the neighborhood business zone, bars are prohibited.
And we have a percentage of sales that have to be by food and a percentage of sales that can be
It
by,
defines a restaurant.
Yeah, there's a formula. It's got to be 40%. I believe it's 40% food, 60%, up to 60%.
Bill Belknap's here. If you'd like to have him recite what the zoning code says, the state's regulation on what constitutes a restaurant selling alcohol by the drink is the state alcohol code.
I'd like that.
Afternoon. The city zoning code doesn't have a specific definition of a restaurant. What we had communicated to the applicant when they were going through their remodel project was they needed to obtain the restaurant endorsement from the state, because if they don't have that, then it has to be posted as 21 and over, which would then constitute a bar. We relied upon the definition that we do have within the city's beer regulations that relate to where hot meals are served. So that was an element they needed to comply with, as well as maintaining that endorsement that brings in then the state's percentage on their sales to ensure that they're staying within the confines of state law of what's required to have the restaurant endorsement.
So in essence, they could meet our code for what constitutes a restaurant. They still need to meet the state code's requirement for a restaurant by definition that is allowed to sell alcohol by the drink, complementing the main income or revenue from food service.
So, for example, if a bar restaurant sold 90% of their sales were in beer and wine by the glass or the pitcher or whatever, and 10% was food, they would not be meeting
They're a
any.
bar.
Yeah, they would not be meeting any of the criteria for a restaurant.
Correct, and the premise would have to be posted as 21 and over and would technically be a bar at that point.
And that would be a reason for the director to revoke the license, so it would also be the reasoning that the city could revoke the license for that.
And since the city does not have